The most significant development of 2016 was the enactment of the Federal Defend Trade Secrets Act, or DTSA, which President Obama signed into law in May. The DTSA creates a private federal cause of action for trade secret misappropriation, regardless of the dollar value of the trade secrets. Because the DTSA's remedies largely overlap with those already available at state law, it's not a radical expansion of available remedies. But the law is still of great significance to employers, both because of the provision of jurisdiction in federal court and the forthcoming creation of a uniform body of federal law in this area. The DTSA is also notable because of its unique provisions, including ex-parte seizure orders in extreme circumstances and protections for whistleblowers who disclose trade secrets under certain circumstances, for example, in confidence to a government official. The DTSA mandates notice about such whistleblower protections in new or updated employment agreements that govern the use of trade secrets or other confidential information. There was a lot of activity this year in non-compete agreements at both the federal and the state level. In March, the U.S. Department of Treasury issued a report finding that non-compete agreements generally stifle employee mobility. Then in May, the U.S. White House issued a report in which they questioned whether or not it did that, whether the non-compete agreements generally stifle employee mobility, or if they actually protect legitimate business interests. Subsequently, in October, the White House then issued a quote-unquote call to action, asking states generally to ban non-compete agreements for low-wage workers, and also encouraging them to be more transparent with their non-compete agreements, and to just make them more enforceable as a general matter, and not stifling employee mobility. Consistent with the White House's call to action, Illinois passed the Illinois Freedom to Work Act, barring non-compete agreements for workers who earn the greater of the federal, state, or local minimum wage, or $13 an hour. Utah enacted a law limiting restrictive covenants entered into on or after May 1, 2016 to 1 year post-termination, subject to certain limitations. Rhode Island and Connecticut both enacted laws this year restricting physician non-competes. And finally, Alabama codified a more middle-of-the-road approach, allowing 2-year non-compete and 18-month non-solicitation clauses for employees, provided that they're limited to the geographic area where the company operates a similar business. In light of the enactment of the DTSA, employers should ensure that their agreements governing trade secrets or confidential information provide notice regarding whistleblowing activities in accordance with the terms of the DTSA. Further, especially in those states that codified non-compete laws in 2016, employers should ensure that their agreements that contain restrictive covenants would withstand judicial scrutiny, and if they will not, revise them so that they are narrowly tailored to a reasonably protectable interest.